And we have seen that very distinctly just recently with the immigration law, which Congress passed, and it now changed the rules for immigration in the Northern Marianas. And they did that without the Northern Marianas having any voting input into that. So, even though the people of the Northern Marianas went through a self-determination process, the result was that they are not self-governing. So it's a flawed process. And in my judgment, they have a continuing right to self-determination until they actually become self-governing. The decision, many of you I'm sure are familiar with the 2005 decision involving the submerged lands. And the Ninth Circuit, this is high on my list for one of the most bizarre federal appellate decisions of all time, because the Ninth Circuit says, well, we understand that the authority of the United States for the CNMI arises solely from the covenant. The covenant gave the Northern Marianas rights to the submerged land, but then the court says, even so, it's irrelevant because Congress has this paramountcy power that overrides the covenant. So even though the relationship is based on the covenant, it's irrelevant because we have other doctrines that are more superior to the covenant. I've read this so many times that it doesn't become any clearer to me anyway. But it's just an example of the fact that the Northern Marianas are not self-governing. They are at the mercy of the United States, and they have a right to move into a self-governing status. So what is a commonwealth? It's a nice, fancy word. It's used in a lot of different ways for a lot of different purposes. So we have the British Commonwealth. We have a number of our states call themselves commonwealths. I grew up in Virginia. They call themselves a commonwealth. Kentucky calls itself a commonwealth. The Northern Marianas call themselves a commonwealth. Puerto Rico calls themselves a commonwealth, but only in English. So here's these are pictures I took when I was in Puerto Rico recently. So it's the Commonwealth of Puerto Rico in English, but in Spanish, it's Estado Libre Asociado in Puerto Rico, freely associated state. So what are they? I mean, they are confused about what they are. Right? Here you see their Judiciary here, Estado Libre Asociado Puerto Rico. So they are truly, genuinely confused. And the decision involving Puerto Rico, of course, is a place of 3 or 4 million people. It's a beautiful, lively island. They went through a negotiation with the United States in the early 50s that led to a kind of a compact. They call it a compact, even though it's a series of documents. The court decisions tend to, the court decisions from the federal judges in Puerto Rico tend to say that this compact governs the relationship, and the authority exercised by the federal government emanated from the compact itself. But Puerto Rico is really at the mercy of the U.S. Congress as well, and Puerto Rico doesn't have any voting representation either. So Puerto Rico really needs to move into a different relationship as well. This is one of the new federal judges in Puerto Rico, Judge Gelpi, and he wrote a really interesting and wonderful case, 2008 opinion. This is all dicta, which means it wasn't really necessary for the opinion, but he went out of his way to say that Puerto Rico is now an incorporated territory, not an unincorporated territory. He wanted Puerto Rico to be an incorporated territory, and he wants the entire U.S. Constitution to apply. He said the insular cases were based on racism, they make no common sense, contrary to the reality of the island at the time. They represent a constitutional antediluvian anachronism. And then, this is an interesting part of the opinion, he then refers to the U.S. Supreme Court decision in Boumediene versus Bush, where the U.S. Supreme Court said that the U.S. Constitution applies to the detainees in Guantanamo in Cuba. And so Judge Gelpi says, well, if the detainees in Cuba can invoke the U.S. Constitution, then obviously the people of Puerto Rico can too. anyway, this is a bit of a digression, but it's an interesting situation. In the Boumediene case, the U.S. Supreme Court did extend the U.S. Constitution broadly, and so Judge Gelby says, well, so it must clearly extend to Puerto Rico as well. But we have a real hodgepodge in terms of how laws apply. So for the 5 U.S. flag entities, there's no consistency. Some laws apply in some laws apply in others. Congress changes the laws. The CNMI used to control its own immigration, now it does not. The minimum wage laws are now starting to apply in American Samoa. So all of these are just whatever Congress feels like doing at any given time. Okay, so I'm getting near the end. I appreciate your patience in listening to all this, but this is a complicated issue, and I wanted to sort of show the various elements of it. So where should we go? How do we move forward on this? Under the United Nations principles, there are 3 permissible outcomes of a self-determination process. Independence, so the Philippines was acquired by the United States in the Spanish-American War, and then it became independent in 1946. So obviously that they're now self-governing, and they've gone through their self-determination. Hawaii, also annexed in 1898, became a state in 1959. So Hawaii is integrated into the United States. Hawaii is self-governing, and by the way, the President of the United States is from Hawaii, born and raised. So obviously we're doing okay in terms of participating fully in the political life of the United States. And so the people of Hawaii as a whole, not the native people, but the people of Hawaii as a whole, are now self-governing, and we've done our self-determination. And then we have the free association option, which we've talked about. So those are the 3 permissible outcomes of a self-determination process. In Hawaii, as I said, the statehood was adopted by a large majority, and so the self-determination process has been completed in Hawaii. But the native people do have a separate and distinct right to self-determination, which we're still working on, and that still is an unfinished process. And the native people are still angry and upset. Okay, now in Guam, we have an opportunity, I think now, to put forward some new ideas. And obviously, the military buildup that you're all familiar with makes it very clear that the United States needs Guam and needs the Northern Marianas. So the United States is going to listen more closely now to the people of Guam, I think, than in other eras, because there's no question but that the national security issues interest of the United States make it clear that the United States needs to pay attention to what the people of Guam want. And so, is statehood an option for Guam? Well, 175,000 people. The population of Alaska, when it became a state in 1959, was 210,000. So, not that much more. So Guam is almost on the verge of having a sufficient population. In 1787, when the idea of territories was first being addressed by Congress, they said 60,000 was the minimum for statehood. Well, obviously, Guam has more than that. And as I said, it's almost at the point of what Alaska had in 1959. Independence, obviously that's an option. There are lots of independent communities in the Pacific, and they're doing fine, and so Guam would still have economic opportunities as an independent country, and it might still allow U.S. military bases for economic reasons, but it could become independent, and that's certainly an option that's available. And free association, as I've said, is also an option, and that can take many forms, many negotiated forms. Governor Camacho said 4 years ago that he thought that the Marianas, Guam, and the CNMI are one. Our destiny, I believe, in the long run, is to be united. And so this is also something to consider in this mix. Should the Northern Marianas and Guam work together, since both are not self-governing.